Hi, I'm Adele Schofield. I'm a Solicitor and Director at Berkson Family Law Solicitors, and today this video is to help explain what a child arrangements order is, what the courts can do to help resolve disputes that you may have when contact arrangements or you don't agree as to where a child should live, and hopefully talk through the steps that we can do as solicitors here at Berkson Family Law to help you resolve those difficulties moving forward. Parental responsibility is a term that is used about how parents have responsibility for their children. Any mother always has parental responsibility. A father has parental responsibility if they're married to the mother at the time the child is born or they're on the child's birth certificate. You can also acquire parental responsibility by entering an agreement with the child's mother, or if that's not possible, ultimately the court can make an order for parental responsibility. And what it is, it means that as parents, you should consult and work together to make the important decisions around a child's upbringing. For example, what medical treatment they may need or have to receive, which schools they need to go to. So those important decisions that you as parents have to make about children, as parents, you should make those together. So that's the principle behind parental responsibility. A child arrangements order is an order that the court can make if parents aren't able to reach agreement about who a child should live with or how much time they should spend with a parent who is no longer living in the household. So it's an order that would define those arrangements for the child or children that you have from that relationship. As I say, it's normally when arrangements have broken down, parties have separated, you've tried to come to an agreement about who a child should live with, how much time you should spend with them, or you have an agreement but you may not be quite happy with it and you want to extend that time. So it's about asking the court to make a decision as to what the best arrangements are for the child or children moving forward, and the court have certain things that they look at when making those decisions and why those orders should be made. A parent can apply for a child arrangements order. Even if you are a father who does not have parental responsibility, you can make an application for a child arrangements order automatically. However, the courts should really be seen as the last resort, and the courts encourage parties to have attended mediation to try and resolve those arrangements themselves between yourselves before you make those applications. So anybody can make the application subject to certain conditions that I'll go on and explain further later. Relatives can also make applications. If you're a grandparent who's not having contact, or an aunt or an uncle who's not having contact for various reasons, you can make an application. But before you make that application, the court have to give you formal permission to make that application. And again, that's something I can address later in the video to explain and clarify that moving forward as well. The court's number one consideration when looking at who a child should live with or how much time they should spend with another parent is the child's welfare is their paramount consideration. That's the main thing that they have at the forefront of their mind when making decisions about children. When applying that, they have something called the welfare checklist, which includes the child's ascertainable wishes and feelings in light of their age and understanding. So the older a child is, the more relevant a child's wishes and feelings will be. Any effect on the child in a change in circumstances, the child's emotional, physical and educational needs, the risk of harm that the child may have been exposed to, the capability of the parents to meet the child's needs for any set periods of time, and also the powers and the orders that the court actually have to make orders. So that's the other issue that the court look at. So it's a list of factors that they consider. Custody is a term that a lot of people use to say that they want to care for their child full time. That is a phrase that used to be used historically in the UK in terms of orders. It then became a term after the introduction of the Children Act of residence orders, and then it's changed again to child arrangements order, live with and spend time with. So it's it's just the terminology that I think is different that people use to describe who a child should live with. The phrase that you will hear solicitors talk about is a child arrangements order, live with, but ultimately it is doing what it says, basically, who a child lives with, who is their primary carer, and then how much time should they spend with the other parent that they don't live with. So that's why the phrase has changed, because it really reflects what is happening for a child on the ground on a day-to-day and a weekly basis. Child arrangements order can be enforced. It is a binding court order. Any child arrangements order has a list of warnings on it as to what happens if you were to breach the order. If an order is breached, the parent who's wanting to enforce the order would have to make another application to court. Ultimately, the sanctions that are open to the court if a parent has breached it, the worst one, and it's very rarely exercised, is a committal to prison for repeated breaches of orders, a fine. They can also expect you to do courses and things of that nature. So that there are sanctions and there are risks that a parent would run if they breached a court order. So it is a binding document. If an application is issued for enforcement, it may be that the parent not complying will give explanations to the court as to why. So the court will look at both sides of that argument, but there are enforcement powers available. If you can't come to your own arrangements around who a child lives with or how much time they spend with the other parent, then the starting point is negotiation. That can be done through a few ways. One way is you could first of all approach a solicitor, and they could write a one-off letter to the other party to say these are the arrangements that we propose. The other party could write back with their proposals, and things may be resolved as straightforwardly as that without the need to go to court. The next thing that you would be expected to do, unless there were risks or there was evidence of domestic abuse in a relationship, would be for you to attend mediation. And what mediation is, it's a third party who is a trained mediator. You would see the mediator, ideally together. It could be remote that you do that. You don't necessarily have to be in the same room. It could be on Teams or Zoom or something of that nature. And they would look to see where you have agreements about time for the children or where they should live with, and where there are areas of disagreement, and help you through talking to you and using their skills as a mediator to see if you can come to an agreement. If that isn't possible, it is then that an application to court will be the last resort in effect. And why I say it's the last resort is because the courts really, one of the considerations they have when making a child arrangements order is, do I need to make an order? Is it to the child's advantage for there to be a court order to arrange who they live with and who they spend time with? So, as I say, court is very much the last resort, and once you're in the court process, there is a procedure that is involved through that process as well, which we as solicitors will be able to explain to you and talk you through, and also support you through as well. A child arrangements order, it is a written document. They try to make them as clear and understandable as possible. It could say, for example, a child spends alternate Fridays through until Sunday evening with a parent, and they have a midweek contact every Tuesday from school until 7 o'clock. It could also provide in writing the structure about school holidays, when you see them at half term, the time that you spend in the 6-week holidays. Are you taking holidays abroad? It provides for Easter and Christmas. Who do they spend time with on those dates? Do you alternate it? And things of that nature. So it does provide a clear understanding for you as parents, but also more importantly, it's a routine and a structure that the child will be able to know and understand, because that's just part of their lived life and lived experiences. So it's a very helpful tool for those parents who have struggled to come to arrangements, that you've got it there in black and white and you know what you're meant to be doing moving forward. The courts are there to arrive at a final order. The court can do that in a number of ways. When you make the application, the court have the opportunity to look at the papers, look at what you've said in your application, and they have what is known as a hearing without parties, just to decide what directions are needed. There will always be an initial letter from an agency called CAFCAS. It's called and known as a safeguarding letter, and CAFCAS makes some initial inquiries before a first court hearing. They make inquiries of you as the applicant and the respondent, the person on the other side of the application are known as a respondent, what your views are about contacts and live with arrangements, and they would also make checks of the police and social services. So this is all information that's then available for the court at the first hearing. They make recommendations as to whether you need further evidence. Do you need a school report, medical reports? Is there a need for police information, or if there are allegations of drug misuse, do you need drug testing? So when you go to that first court hearing, the court know where each party stands, and if there's any possibility of arriving at an agreement at a first hearing. It may be that there isn't, but you can put in arrangements, and the court would encourage what are called as interim contact arrangements. It could be for contact to start on a supervised basis, professionally supervised or supported, or if there really isn't much agreement, the court can appoint a CAFCAS officer who will undertake a piece of work with the parents and also involving the child or children on understanding what their wishes and feelings are. So the court ultimately can help by having all of this information and evidence. And once you've got all the CAFCAS report and any other additional evidence and statements as to what and why you think things should work a certain way, they will see if you can reach agreement. If you can't, the court will have to hear evidence and make a final decision on what is in the child's best interest using the welfare checklist I've spoken about earlier. So yes, the court can help, and there are various interventions at various stages the court can use to try and get those arrangements in place. As I've said about the welfare checklist, one of the factors that are looked at are the child's age, wishes, thoughts and feelings. Now, if a 12 or 13-year-old is saying, I don't want to go, and they're giving tangible reasons as to why they don't want to go, it could be a whole host of reasons, but there could be their wishes and feelings carry more weight than, say, if a 5-year-old was saying, I don't want to see the other person. If a 5-year-old doesn't want to go to school, they're told they go to school, and it's easier to tell a 5-year-old what to do. But there are sometimes reasons that the court will know why a child doesn't want to go. For example, the court may have established through a separate hearing called it a finding of fact that there was domestic abuse in the relationship, and the child may have seen or observed that, and therefore that could be a good explanation why a child who's maybe a little bit younger doesn't want to go on contacts. And the court will then, because the court's primary aim is to make sure a child has a relationship with both parents, look at what can be done to promote a relationship between a child and a parent who's been found of domestic abuse safely. Is there anything that can be done to promote that? So as I say, it is a factor that's taken into account, but it depends on the age and the circumstances of that particular case. Hopefully I've covered and answered some of the questions that you might have about child arrangements order. They're always difficult and emotional. Every case, both parents love their children and want to see them and spend as much time as they can with them. So hopefully I have explained that. We at Berkson Family Law Solicitors, though, are experts in dealing with children and child arrangements cases. We have the knowledge, we know how to support parents through what can be difficult times, and also for those parties that have evidence of domestic abuse and a low income, legal aid could also be available to assist you through that court process as well. So yeah, contact Berkson Family Law Solicitors. We're the ones that have the expertise to be able to help you through every step of that journey.